Good afternoon. Thank you for joining our webinar today on the Builder's Remedy for Housing, what agencies, developers, and advocates should know. Our speakers today are from our Land Use and Environmental Law Practice Group. Joining us are Shay Dively, Russell Morse, and Kiana Amiri Davani. Before we get started, I just wanted to cover a couple of housekeeping items in the Zoom webinar room. A couple of new features. One, we have enabled closed captioning. If you wish to turn that off on your end, at the bottom of your menu button, there is a CC transcript button that allows you to hide that if it tends to be distracting. The other thing to note is we are in a webinar format. Therefore, all cameras and microphones are muted on the attendees' end. Should you have any questions for our presenters, please use the Q&A feature, and that will send those to them. If you have technical issues, please use the chat feature and I will assist with those. We will be posting a copy of the recording on our website and distributing a copy of the PowerPoint and any MCLE certificate by the end of next week. So please anticipate that in your email box. And with that, now I'm going to turn it over to Kiana to get us started.
Thank you, Valina, and thank you to all of our attendees today. Next slide, please. So today we are going to generally discuss the history and the background of the Builder's Remedy, the application and process for a Builder's Remedy project, and lastly, cover current litigation and legal questions. Next slide. As a reminder, we all know this is a dynamic and evolving issue, and thus this webinar is to be used for informational purposes only, because it is subject to change. Feel free to reach out to our presenters in the Myers-Nave Land Use and Practice Group should you have questions following the presentation on particular issues. Next slide, please. So starting with a refresher and history on the background on the Builder's Remedy. The Builder's Remedy was enacted in 1982 as part of the California's Housing Accountability Act. The Builder's Remedy places limits on the ability of certain local agencies from denying certain housing projects. Specifically, it applies only to local agencies without compliant housing elements, and it applies to housing projects with specified portion of qualifying affordable units. So if it has been around since the 1980s, why is it such a hot topic now? Well, in the past, many have found that the statute was poorly drafted and confusing. It was unclear whether it was worth losing political clout with local agencies to pursue. Additionally, California housing crisis has continued to worsen throughout the years, and the legislature has greatly strengthened housing element law to address the housing crisis. In the past, there has also been a period for local agencies to come into compliance, a grace period for local agencies to come into compliance. However, this grace period was not provided in the latest 6th cycle of the housing element. So we're seeing this perfect storm where you have local agencies, more and more local agencies that are without an approved housing element. And at the same time, there's a push for more affordable housing. Next slide, please. Again, this focuses on affordable housing. So looking at who and what types of projects apply, landowners or developers with Builder's Remedy applications for projects that are for housing development, including up to 20% of the total units available to lower income households, or this applies to projects where 100% of the units are available for moderate income households. That means that if you have a 20% of a project with 20% of units available to lower income, the 80% can be for other uses. Next slide, please. So looking at the limitations for a local agency to deny a Builder's Remedy application, there are 4 codified in the government code, which include: 1, a city may deny or impose conditions that make the project infeasible if the local agency makes written findings that a city or county has met or exceeded its regional housing needs allocation. 2, the project violates written objective health and safety standards that were in place at the time the application was deemed complete. 3, a denial is required to comply with state or federal law. And lastly, the project is located on on land zoned for agricultural or resource preservation, or the project is on a site that does not have adequate water or sewage facilities to serve the project. Next slide, please. Additional limitations to the builder's remedy include CEQA, our favorite statute. So where projects require different discretionary approvals, they are still subject to undergoing environmental review under CEQA. Currently, it is unclear to what extent a local agency can deny a project based on CEQA review, but we'll be talking about this a little bit later in the presentation. And now I'm going to pass it over to Russell.
Thanks, Kiana. I appreciate that. And with that, yeah, let's kick off our portion on the application and processing of builder's remedy projects. As Kiana said, we're presenting the builder's remedy as we see it unfolding across the state. It is in constant flux and it is changing. Per our latest stats and latest research, there's approximately 24 local agencies that we're aware of with builder's remedy applications pending. But again, this is changing. These agencies vary, across the state in terms of the number of applications, but City of Santa Monica leads the way with 16 total applications, although I believe 14 of the 16 are from the same developer. Local agencies have taken different approaches to builder's remedy projects. Some have embraced them. Some have agreed to process builder's remedy projects without positing on their merits. And others have flat out rejected the builder's remedy, like we're seeing in cities like Huntington Beach, that considered even prohibiting builder's remedy as an available application. Going back to Santa Monica for a second, because there are 16 applications there, that is unique in itself in that the builder's remedy applications provide for a total of potentially 4,500 total new units. I believe that's the most in any particular local agency for builder's remedy. And of those 16 that filed a preliminary application for a builder's remedy project, which we'll discuss in a second, 14 have followed through and actually filed formal applications to keep the process moving. Next slide. So, as I mentioned, builder's remedy applications are typically filed using an SB 330 preliminary application. SB 330, known as the Housing Crisis Act of 2019, was drafted and approved by the legislature with 3 general aims. First, to increase residential unit development, but also protect existing housing inventory, but also to expedite permit processing. As part of SB 330, a new preliminary application form was created in an attempt to make the development review process faster and provide some certainty to a housing development project applicant by identifying what application materials are required and by locking in the development requirement standards and fees at the time the complete application is submitted. Local agencies are supposed to prepare their own SB 330 applications under the law, but if not, an applicant can use the HCD SB 330 form, which is provided here and on their website as well. It's a relatively simple form. I believe it's 14 questions with subparts on 8 pages. and general questions regarding the project itself and its location and site. However, a site plan and elevations must be submitted with an SB 330 project. So that will require the use of an architect to provide accurate site plans and elevations. An applicant must also submit a processing fee for the SB 330 application in order for it to be complete. And then once filed, the applicant has 180 days after submittal to file their complete application. And at that point, the development process starts and a complete list determination can be made. A preliminary application can be amended after the filing. However, there's general limitations on that. Typically 20%, you can't change more than 20% of the number of units or the square footage. Next slide. So after submitting a SB 330 application, the filing of that preliminary application establishes vesting of the ordinances, policies, and standards adopted in effect at the time of submittal. The local agency is not required to make a formal determination about whether the preliminary application is complete. Rather, that if the preliminary application meets the list of required items, it is considered deemed complete. Next slide. There's been a lot of talk about how vesting plays a role in a builder's remedy application, which we will address in a moment. But before that, let's briefly sort of tee up some timing questions and timing issues related to builder's remedy applications. As shown here, there's a few scenarios that can play out with respect to filing of builder's remedy applications. You know, as we know, the housing element deadline for many jurisdictions, such as in SCAG and ABAG, have already passed, but it has not passed for other jurisdictions or local agencies. So there's this period of when the housing element deadline has passed to when a local agency adopts a housing element, which is sort of what we see happening across the state in terms of processing. And then following HCD certification. Now, I will note, however, that HCD has taken the position that where a jurisdiction submits an adopted housing element before submitting their initial draft or considering HCD's findings on an initial draft, HCD will consider the adopted housing element to be an initial draft for purposes of both HCD's review and jurisdiction's compliance. The HCD in a memorandum recommends that a local agency adopt their housing element only after receiving a letter from HCD finding the draft meets statutory requirements. In addition, HCD has posited that it believes that for a housing element to be found in compliance, the local agency must receive a letter from HCD affirming compliance. Therefore, according to HCD, a jurisdiction does not have authority to determine that its adopted element is in substantial compliance, but may provide reasoning why HCD should make a finding of substantial compliance. A jurisdiction is only in compliance as of the date of HCD's letter finding the adopted element is in substantial compliance. So without opining on the merits of this declaration, I can tell you that is not the position of some local agencies, or that the position that some local agencies have taken on this, and it remains unsettled. And so what does it all mean? Unclear. I think really only the potentially indisputable time to file a builder's remedy application is after that deadline is passed, but before any action is taken on approving a housing element. And it may mean that my simple arrow chart here is not even correct. This is all to be determined. Which brings us back to my prior question, which is what happens if a local agency receives certification after the preliminary application for a builder's remedy project is filed? Next slide. And again, the answer here is that it's unclear. HCD has made an unequivocal statement that it believes a builder's remedy project preliminary application filed pre-certification is vested and can be continued to be processed as a builder's remedy application regardless of later action. But again, we note that this is HCD's take, and HCD's determinations are not law. So again, this remains unsettled. Next slide. So what happens, after a builder's remedy application is filed? We file an application. How does processing work? Under the builder's remedy application, the argument is that zoning ordinance and the general plan do not apply. But that's not the end of the story. As Kiana alluded to earlier in the presentation, it's clear that other state law, such as CEQA and the Coastal Act and the Permit Streamlining Act, apply to builder's remedy applications. The builder's remedy application does not affect the discretionary CEQA process that every project must go through in California. However, CEQA exemptions, such as a Class 32 infill exemption or the use of streamlining under a number of provisions, statutory provisions such as SB 375 may apply. SB 375 in particular is provided as a CEQA streamlining option and allows for processing of projects under an exemption or under a sustainable communities environmental assessment, also referred to as a SKIA. A SKIA is a CEQA streamlining tool available for housing projects with a density greater than 20 units per acre that are located in high quality transportation areas and consistent with the tongue twister, the Regional Transportation Plan Sustainable Community Strategy, the RTP-SCS. Some developers have taken this route with builder's remedy applications because a SKIA does not require a finding of consistency with the general plan or zoning designation, but only requires consistency with the applicable RTP-SCS. With respect to the Coastal Act or the coastal zone, we simply note that the Coastal Act is not constrained by builder's remedy, and therefore a local agency or the Coastal Commission could deny a otherwise viable builder's remedy project for reasons related to the Coastal Act. So therefore, cities like Malibu, which are entirely in the coastal zone, may have far less or even zero builder's remedy project applications due to development constraints for projects in the coastal zone. I also note that the Permit Streamlining Act does apply to builder's remedy projects. The PSA under the government code sets strict time limits for local agencies to act on proposed development projects, including a requirement for a lead agency to approve or disapprove a project within a number of days from certification of an EIR. Sort of as a final point, sort of touching on these issues here, in the next slide, I will note when processing a builder's remedy application. Oh, sorry, can you move to the next slide? Yeah. There are certain SB 330 rules in play here. As I may have mentioned, SB 330, among other things, does impose a 5 hearing rule, a maximum of 5 hearings, which are generally very broad in scope. Are the limitation, the maximum number of hearings that a local agency can have on a particular project. And SB 330 also shortens the time frame for approval of a housing development project following CEQA review. I note that a local agency cannot use CEQA and must be careful to avoid the appearance of using CEQA the CEQA review process to delay a housing development project. HCD has not been hesitant to involve itself in projects where it feels that CEQA is being used as a shield by local agencies to potentially delay housing development projects. I will note, however, that I would be remiss if I didn't mention a recent decision in San Francisco, the 469 Stevenson case, which may also play into this this builder's remedy world that we're living in. The 469 Stevenson case, it was decided in October of last year. And I think it's safe to say that it was a surprise win for local agencies. The case centered on a mixed-use project of approximately 500 units on a vacant parcel. And the EIR was prepared. Planning Commission approved the project back in July of 2021. In October of that year, on appeal, the Board of Supervisors overturned the approval based on concerns about EIR issues including related to seismic concerns, effects on historic resources, and gentrification. In November of that year, as I mentioned, HCD opened an investigation and sent a letter to the city regarding the project and its concerns with respect to its lack of approval. I will note that in January of 2022, without the project being fully decided, Yes in My Backyard, or YIMBY, a pro-housing organization that's sort of been at the forefront of housing in the state, filed a lawsuit against the city for violation, among other things, SB 330, the 5 hearing rule, the Permit Streamlining Act, and CEQA time limits, and for violation of the Housing Accountability Act. On demurrer, in October of 2022 of last year, the court sustained the city's demurrer on all of those claims, holding that there was no violation of the 5 hearing rule, no violation of the Permit Streamlining Act, because an EIR hadn't been certified yet. The time limits, it held that the time limits for agency action under those statutes do not apply, and because the EIR had not been certified. It also held that there was no violation of the CEQA time limits, because CEQA does not, quote, contain automatic approval provisions, and its time limits are directory rather than mandatory. It did also deny the housing accountability claim, because the court held that the applicability of the Housing Accountability Act decision can only be determined again after the EIR was certified. It didn't matter that the city didn't make findings under the Housing Accountability Act, because the Housing Accountability Act for the decision did not apply. What does this all mean? Again, it's sort of another piece of this unfolding builder's remedy puzzle. It's possible that it may mean that CEQA will remain the dominant statute in housing and California housing law. But I will note that this is not a binding decision. It is a trial court decision, and I don't even believe it was appealed. So I'll leave that there as sort of, another piece to this puzzle of where we are in this world, as it is constantly changing and evolving. So with that, I will turn it over to Shay to try to shed some light and discuss the current state of litigation in a housing element world and builder's remedy.
Thanks, Russell. Though I think you kind of painted a rosier picture of what I'm going to say, then perhaps you overpromised what I could say here, mostly because this is really, as we've stressed throughout this whole time, and thank everyone for joining us today. It's really an ever evolving and changing and unsettled world in terms of, and I see a bunch of questions in the chat already, and we're going to address them toward the end, but we're probably not going to address them. I'll be honest, because it's very much changing, and there's not a lot established so far in the case law, and that's kind of par for the course, given the kind of nature of the builder's remedy and kind of how it is and how it's drafted. Next slide. I did want to talk a little bit about kind of what we're talking about when we're talking about remedy litigation involving the builder's remedy. We're really talking about kind of 3 main buckets. First, there's we are seeing a lot of civil right actions being filed by that actually, it says NIMBY, it should be YIMBY. I apologize for that. That's definitely not a NIMBY. It's a YIMBY situation where they're for local agencies that are do not have an adopted housing element or certified an adopted housing element yet. We definitely are seeing a wave of lawsuits across the state filed by the various YIMBY groups almost immediately after the deadline passes because of being just out of compliance. It's a pretty simple, and these writ actions actually kind of look identical and kind of are cut and paste and just with a different local agency as the respondent. And we're also for the same, there's also enforcement actions filed, by HCD or the AG for also if there's been a delay or an undue delay, let's say, of a lack of a housing element. What we haven't seen as much yet, but we do expect to see is going to be in the second bucket, which is going to be when we have either approval of builder remedies projects or denial of builder remedies projects. We will see this most likely see developer suits to force the approval of project applications, but we also expect to see project opponent suits challenging the approval of some builders remedy projects as well. And then I think our third bucket is really kind of this what I call wildcard litigation, which I think a classic example is just the Huntington Beach situation where that they after the AG filed an enforcement action against them, that they turned around and filed a federal action to try to enjoin the operation of state housing laws against it, which that injunction was recently denied. But and we might see other kind of more wild card kind of cases that don't fall squarely within one of the other buckets. Next slide. So when we're talking about the housing element cases, because things remain very much in flux and a lot of uncertainty here, it really brings up a lot of questions that haven't really been settled law. And basically we see the like whether or not the ability to establish substantial compliance with state law without HCD certification. There is some foundation in the law for this. But then I would also say the next bullet where we talk about the level of deference given to HCD. There was a case that came out just last Friday. That's an example of how changing everything is, that we need to update slides and update discussions like day by day. The Martinez versus City of Clovis case, which definitely had the statement that the courts will generally not depart from HCD's determination unless it's clear erroneous or unauthorized. That case did not deal with a builder's remedy or a housing element in this cycle. It was the last cycle. But the kind of message from that case, at least was the idea that perhaps HCD's determinations would be provided more deference in the courts than what maybe we saw like in the City of Gilroy case in the past. So, and this is important because of what Russell brought up earlier. It really is going to be how are the arguments of HCD going to be presented in these cases, especially if we're going to talk about in the next, also with the next bucket of cases for the builder's remedy, is we were talking about that HCD has really issued a lot of memos and opinion statements and on whether or not, how things are vested or whether or not they're vested and whether or not a city that's a local agency that's doesn't have a certified housing element, how they can be in substantial compliance. And HCD definitely has opinions, and it's unclear right now what weight the courts are going to give to HCD's opinions and kind of determinations. I mean, and in the past, it's been often local agencies, like it's good to rely on some HCD's determinations because it gives a presumptive, it shifts the burden of proof. Like if you have an adopted housing element, it's considered valid. It's, you have the HCD determination to support it. But right now we're in a bit of a wild west situation where we're unclear about what these other statements made by HCD, how much weight the courts are going to give it. I would also have to say that, you know, because as I mentioned, we're seeing just like dozens of writ cases being filed by the YIMBY groups across the state, that these often are settled and settled fairly quickly. And again, that should be YIMBY, not NIMBY. It's often the settlement, the public, we've seen in the public settlement documents, it's really adopting then HCD's interpretation of some of these vesting and timing issues for builder's remedy applications. So even if it's strictly, even if they're being sued for not having an adopted housing element, it has it has repercussions for the builder's remedy case. So they really go hand in hand. Even if there isn't even an active builder's remedy applications out there, that's obviously the intent of some of these lawsuits, is to provide some degree of paving the way, or trying to establish some certainty through settlement of how these applications will be processed. And so that's just something to kind of keep in mind as these cases move forward. Next slide. So for the same reason, kind of, I already touched on these, for the builder remedies application cases, because we really haven't seen these issues actually, you know, litigated out at a public in a published decision by the Court of Appeal, there's a lot of uncertainties. And Russell and Kiana both, we've all touched on this. We've touched on it from the very beginning about how the law is constantly changing. We have issues in terms of just the timing uncertainties. Like I see a question that came in actually in the chat about like what happens when a builder's remedy application is received while HCD is conducting review, or the timing, exactly what Russell showed in his little arrow slide is, what happens, the timing of when the application comes in, what does the local agency have to do to comply with the law? And it's very much unclear, because to be honest, it was a poorly written statute from a long time ago, decades old, and it really hasn't been fully ever litigated and clarified. And then also, there's a question of what happens once a housing element is adopted and certified, and if applications are still pending, what happens with those applications? Do they still have to be, processed? I mean, that's what HCD says, but again, HCD's its opinion. It's not the law. It hasn't been established. I think it's also a question, just even from a practical standpoint for local agencies, that if you're in the process of working on your housing element and getting it adopted and getting it certified, and you get a builder's remedy application in, do you actually address that builder remedies application in your ongoing work on your housing element? If it's a site that you haven't already delegated the unit, the RENA numbers for that site, do you go ahead and put it in and go ahead and do your zoning for that? And that's an unanswered question, because if you don't, then it's going to be this inherent disconnect in what happens down the line. Also, with brought up about the preliminary applications and what Russell was talking about the use of the SB 330 applications, I think there's a lot of questions of what exactly what exactly gets vested, and whether or not in terms of completeness and amendments. And that's because, though it looks like a simple application, as Russell pointed out, there is, you have to provide elevations, you have to provide site plans. So in terms of just saying, oh, that's complete, it's a little bit more uncertain, and how that will actually play out in court is unclear about whether or not there is, some grounds for denying, or at least seeking additional information and things like that. also, of course, just even haven't been fully litigated on just the grounds of denial of applications. We listed the four, Kiana listed the four at the beginning. But there's again inherent uncertainties and some about how those are interpreted and what that actually means. And finally, there's exactly what Russell just mentioned about the whole question of intentional CEQA delay. And if a local agency can be held to say that they are intentionally delaying CEQA, what does that even mean, and how does that really play with that statute? These all are very open questions that have not been settled by any court of any published decision. Next slide. So that kind of brings us to the point of our I'm going to kind of wrap it up, and then we're going to talk through some of the questions, but I thought it would really make sense to kind of provide an overview of what we're really talking about here and about the future of the builder's remedy. And it's important to remember that the builder's remedy lasts until a local agency's housing element is in substantial compliance. So we really are talking about a relatively short-term period of time in the grand scheme of things. And so it really only comes up, at a particular time in this particular cycle of this particular this cycle of the housing elements. So it's really kind of unclear about whether or not this is a big deal or a small blip. And it's also kind of unclear, is this inherent uncertainty then in the builder's remedy statute actually helping things? Like, is it contrary to the actual intent of the original law? Like, is it meant to be a hammer, or is it the means to bring more housing on? Because all these uncertainties does not really provide a clear path for a clear path for more for a significant amount of more housing to come online because of all this inherent uncertainties. And there might actually be better processes and better application processes that would provide more certainty than going this route. And so it really is this kind of wild west of housing, and it very may well be that the legislature is going to step in with a new state law to try to fix this or provide more clarity. And I mean, we've seen just so many bills from the legislature in recent years to address the housing crisis, and everything seems to be done to kind of to streamline and to allow housing to go forward, as we're saying that because of these uncertainties here, this is not a clear path. So it's very likely the legislature might step in to try to fix things. I'm not saying that then their fix will actually make things easier or clearer. I mean, that's part of the problem, is that SB 330 actually, even though you think it would add some clarity, it actually adds this other overlay on it that becomes then some inherent kind of other uncertainties involved. So and so that's what makes this an interesting talk to have today, because of all this kind of the broad range of uncertainties, and just the broad range of how different local agencies and how different developers and how advocates are all addressing this. Next slide. So we are now going to attempt to address some questions in the chat. I just want a reminder that, as I've said now several times about this degree of uncertainty here, we can do our best to answer questions, but we really can't opine upon any particular situation for any particular local agency or jurisdiction. I will say that, if you have any particular questions about your situation, definitely feel free to reach out to one of us on this call and to us in general. But I think let's take a look at some of the questions, and I'm going to invite Russell and Kiana to open their mics so we can kind of talk through maybe a few ideas. I know we got one question about the grounds for denial under 65589.5D. Kiana, I know that was kind of under yours, that came under your side. Did you have any, did you want to provide any thoughts about whether or not you could be able to condition that a developer build water or sewage infrastructure in order to approve a project?
Sure. So while it is within the local agency's authority and discretion to impose that sort of condition, it seems like it would be more likely that they would just deny and tell the applicant to provide a different, go through a different route instead of going down the builder's remedy application.
That's right. I mean, again, it's hard to say. It's difficult because of our, as I said, this is just like a limited period of time is kind of what, like Kiana's earlier slide, we're talking about just a limited number of limited projects for limited jurisdictions. So at a certain period of time, sometimes it might be hard to, maybe a project doesn't fit within the builder's remedy slot, and it maybe could be better processed and approached through a different way. And I don't know, Russell, did you have any further comments on that?
Yeah, I was wondering if that was more just sort of a general Housing Accountability Act question or specifically related to builder's remedy. I would say that, right, as long as, a local agency is allowed to condition development projects, as long as it doesn't, deny or make infeasible that project. So I think that it's not that a local agency cannot condition a developer.
Yeah, I mean, the builder's remedy is not just like free reign that you can build a project without sewers, I guess is right. So let's keep going. There's a question about the project. If a project is exempt from CEQA, do you think it takes the project out of the discretionary process? I'm just going to answer from a CEQA perspective is no. I mean, actually, an adoption of an exemption is still a discretionary decision by the lead agency. But what I think is interesting is, is like an SB 35 application, which does then become ministerial, but now I'm getting more complicated that we need to be. So I don't know, either of you have anything to add on that?
No, I agree. I think even with a CEQA exemption, there is still a discretionary process that needs to be followed through and approval by typically a planning commission or some other type of board.
So there's an interesting question about the 5 hearing rule. And I don't know if I have an opinion on that, but I think we should talk about it because I think this what the question is whether the 5 hearing rule applies to builder remedies projects that do not comply with either the general plan or zoning code because it says it applies to housing developments that comply with both.
Mm-hmm.
And I think that is this problem with we're talking about all this is that it's an inherently circular it's that obviously, well, I don't know, how do we want to discuss this one?
I think it's a very fair question. It's a really good question, and
yes,
it highlights the vagueness or lack of clarity in how this will all work itself out. I'm not
so yeah, if you hold that 6 hearing, will you get a lawsuit?
Mm-hmm.
I can't say. I just don't know. It's this I mean, I think that's because of, as I said, I think the overlay SB 330 put on the builder's remedy, it doesn't, they weren't written to nicely mesh.
Yeah.
Right?
Mm-hmm.
I don't know. It's hard to say. let's look at,
I say, all right, for Burlingame, we apologize. I must have wrote it down wrong. We will remove that from our slide deck.
you know, these are both interesting questions that I'm trying to decide. Your question about, do you want to take that one? Where, I'm sorry, I'm trying to see. Should we do, so, there's a question about the legislative history, that whether or not there's anything that clarifies, and I mean, I looked at the legislative history for 65589.89.5 before. I mean, the problem is, well, we should say this, is that, I mean, as we mentioned, I mean, I think the legislative intent for the builder's remedy was that it was supposed to be a hammer, a threat. And so what makes it interesting, intellectually interesting and confusing, is that, is this really meant to have ever been an alternative application process for projects? From like, you know, from just the standpoint of, you know, like, oh, this is just another pathway for, like, if you could have a project that would fall under this category. And so I think some of these then questions about how to interpret some of these provisions, which aren't made for necessarily, like, they're made for Housing Accountability Act questions, less for the builder's remedy, because it was really meant to be like a hammer and like a punishment. What do you say, Russell and Kiana? I mean, do you have any, this is strictly now being kind of opining on how to mine the legislative history to kind of assist this. I don't know.
Yeah, no, I've reviewed some of the legislative history and seen what others have said on it. You know, the builder's remedy, as we know it, appears, like, as Shay says, to have been thought out as a process for what happens when a local agency does not have a compliant housing element. But again, yes, it is supposed to be a hammer. It's supposed to be essentially a not so veiled threat, but how that all works out is entirely, you know, undetermined. And yes, the language is not clear at all. And so there's no process for fixing what has been started without, you know, some future clarifying legislation, you know, by the legislature.
I think that's true. So, okay, let's keep. Do we want to look at what the denial on grounds that have been identified as a flood hazard or wildlife wildfire interface? Where was that one at? Do you want to take that?
Right.
Kim? Trying to look for it.
Yeah, I think, well, it seems like that would fit either under if there's an objective health and safety concern, or if, you know, it would be subject to CEQA review as well. So it could fall under one of the two different limitations to the builder's remedy application.
Right. In which case, right, a local agency would need to make written findings to that effect.
So, so then the next, we get another question about, sorry. We are skipping over a few questions that were specific to jurisdictions, and we're, as we said, we can't really opine on particular examples, mostly because everything's in flux. And as I said, we're happy to talk if anyone wants to reach out individually. We are happy to talk with people about particular situations.
Do we agree?
I don't know if I could answer that question about HCD denying housing element applications to law for builder remedies projects. I would say assumes, I cannot answer for HCD.
Right. Would you agree that the ultimate determination of the housing element substantial compliance is up to the courts, based on Fonseca?
I mean, there is an argument. Yes. I mean, I'm not going to say I'm saying that is an argument made by it. I mean, that is a holding that you could take from Fonseca. But the problem is that the courts have also held that HCD's determinations have great weight.
Mm-hmm.
And so then it becomes, what if you have conflicting, what if, how is the court going to address a situation where HCD and the local agency are in disagreement over whether or not they're in substantial compliance? And I think that's, I feel like, and that's the problem with the Martinez versus Clovis case, to be honest. I mean, I think there's a question of how far, it's a possibility that someone can take that generous language in that case on HCD's, the deference afforded to HCD. I am not going to answer. There's a question about, well, I don't know how we, sorry. Is there, we have a question about how do we get the legislature to fix things? I think as things get more and more wild, I do think the legislature is going to step in because of, we're still, I think the key is we're kind of still at the beginning of how potential of this kind of part of uncertainty, because at least up here in Northern California, the deadline was January for the housing element. I know in Southern California was what, last year? Was that right? Too. So, and then there's still some 6 cycle remaining places that are still working on it. So we're kind of in the middle. And I think, I don't think we've seen the full kind of how this is going to play out and seeing the courts having to grapple with it yet. And I think that's when, if we start getting contradictory decisions or more and more uncertainty where local agencies, well, and to be honest, we're going to say of everybody on board, like if both local agencies and developers are unclear about what the path is, the legislature will likely step in to try to clarify it. But my point really is that I'm not positive, even if they try to clarify, if it will make it clear.
I see a question here. Does the builder's remedy apply in industrial zones? And I believe there's also one about applying in non-residential zones. And I think the answer to that is potentially it does apply to industrial zones because it's inconsistent with the general plan land use designation or the zoning ordinance. Would it be a good idea to file a builder's remedy application in one of these zones? That's for it's a very sort of project specific type of question to determine based on other factors. It may not be a particularly good idea if there are other CEQA or other related issues, public health and safety issues that could come into play.
Yes, just adding on to that, I agree, Russell, that you'd have to look at if there are health and safety standards that could deem the project infeasible, as well as if there are any state or federal laws that would impact the proposed project from being developed in an industrial area. So look out for those limitations.
We have a question about if a builder remedy, the preliminary application is incomplete and with some of the required information not provided. Like they're not like specific information required to be included in a site plan, shouldn't the agency return it? I mean, I think generally, I mean, again, we can't provide direct legal advice on a specific situation, but yes, I mean, the point of the preliminary application is that it has to include all required information. If it does not, it is not a preliminary application, correct? So it really needs to be returned and filled out correctly. As I said, I think it's an open question for the courts as to what that really means and how it can, and whether or not it can be amended. Like if you filed a preliminary application and you change your project in some fashion, are you really allowed to rely upon that original preliminary application? You know, the way the HCD application is written, it says within 20% change, but what if it's some other amendments or something else? Like I just think it's incredibly uncertain, and it doesn't provide a lot of clarity in that respect. Let's see. Anything added? Anybody else?
I think there's a follow-up question to, are you saying that a builder's remedy project can only be approved on a residential parcel? And I don't think that is true. I think it is potential a builder's remedy project could be approved on a non-residential parcel. That said, it is very project and site specific, and really depends on the situation. Important to do your due diligence and make sure that it would be a good candidate for a builder's remedy project if that's the case.
There's a note that I agree. There's a note that the deference afforded to HCD in the Martinez case was in the context of the HCD approval of an element where there's a rebuttable presumption that HCD is correct. I agree. I'm just saying I think the court used overbroad language. I'm just going to be honest. So I'm just putting it out there as a warning of how that language is going to be used in other places.
And I think we have time for maybe one more question, looking at the time.
Mhm.
So there's a lot here. What should we do? Try to find some ones that we can. I think there's a question about if a housing element is adopted locally and is approved, is certified by HCD, but full compliance is depending upon the zoning. I mean, I would say that it's a compliant housing element. But I'm not providing legal advice.
Right. Yeah, I'm not sure it's that clear.
I don't think it is that clear, but I think it's a good argument.
Within quotes,
Yes.
and it depends on the you know, on the circumstances, I would say. Right, is HCD saying that you're only going to have full compliance when the rezoning occurs or whenever that might be? You know, and again, I think,
Yeah, if it's a conditional certification upon certain things happening, I think it's unclear about how much you can rely at what the degree of reliance on it.
mhm.
What else can we do? Is there any other ones to?
The jurisdiction has met its RENA in all categories. Is the jurisdiction still subject to builder's remedy applications? Well,
I think it's grounds for denying it, right?
I believe it is. I mean, I think if there is not an approved housing element, then the builder's remedy application could be filed, in theory.
But it doesn't mean you have to, but if it's grounds for denial, then
But there is a
It
potential
is, yeah.
file
Yeah.
under, right, 65589.5. So yeah, I would agree.
51.
Mhm.
I mean, that is the key. I mean, I think maybe that's like maybe something to kind of close with a little bit about that. This is all everyone's been talking about. Like the builder's remedy is, I mean, that's why we held this webinar today. We'll continue to talk about it. But I think that because it's all everybody's talking about, there's a lot of like thought of, well, I should, people said we should file a builder's remedy application, but maybe that's not the right process for a particular project. That doesn't, just because it's potentially available doesn't mean it's actually available for your project in the jurisdiction that you're applying for. Just because there's a lot of talk about it doesn't make it the right process. I don't know.
I think that's a fair way to end is, right? We're trying to provide an overview of builder's remedy and what we've discovered based on our research and review of what's happening here, and hope that it's been helpful to at least sort of put it all together as it currently stands, with the caveat that it is, constantly changing and evolving and will continue to evolve. So yeah, thank you all for joining, and hopefully we provided some information to on the builder's remedy and where we are with it.
Yes. Yeah, we could put our last slide up, but thank you everyone. And we really appreciate this time, and please, again, contact us with any questions. We're happy to talk. As we say, maybe this is the first of many, and as things develop, we'll have more definitive things to say, but it really was kind of opening, kind of an opening time to talk about this. And really, there's some excellent questions. We're going to save them all, and we may follow up with certain people later too, if you're happy to follow up with us as well. So thank you so much.
Thank you all.
Thank you.